Recently, tax residency has become a contentious and difficult issue. We asked Tax Partner Fletch Heinemann to explain some of the basics.
To be a tax resident of Australia, you need to satisfy one of 4 tests under the Australian income tax laws. You don't need to satisfy all of them, just one will make you a tax resident under the domestic law. So those tests are if you reside in Australia, based on the ordinary meaning of the word reside, if you have a domicile of Australia and you don't have a permanent place of abode overseas, or if you're in Australia more than 183 days in a particular income year. And the last test is that if you're a member of a particular Commonwealth superannuation scheme for prescribed employees. So that typically applies to members of the armed forces and other Commonwealth public servants, for example. The first test of residency is where a person resides in Australia. Now, the first thing to note is that it doesn't mean whether you reside overseas. The test is whether you reside in Australia, and it's possible to reside in more than one place at the same time. So some of the old cases talk about a person who has a home in London but also has a home in the country in England. And the more modern day example is that of a fly in fly out worker who might have a family home in Australia but would also have a home in the overseas country where they're living and working overseas. So the ordinary meaning of the word resides means that you have a usual abode or a settled abode, or that it's somewhere that you dwell permanently. So when you take into account various factors such as family connections, your economic connections, the routine, your settled routine and what you do on a daily basis, you then get a result as to whether you continue to reside in Australia or whether Australia is just somewhere that you come to visit in between your settled routine overseas. The next test is if you have an Australian domicile, you need to have a permanent place of abode overseas. Now, everyone gets a domicile at their birth, but you can also acquire a domicile by choice. So an easy example of a domicile by choice is somebody who becomes an Australian citizen. So for people who have an Australian domicile, you need to have a permanent place of abode overseas to not be a resident under this test. So what does permanent mean? Well, the cases are clear that permanent doesn't mean forever. It doesn't have to be everlasting, but it must be contrasted with temporary or transitory, for example. So if you're only going to be overseas for a short and finite period of time, that's probably not going to be a permanent place of abode when you're overseas. And similarly, if you've got circumstances where you're moving between countries, you may not actually be in a country for long enough for that place to become your permanent place of abode. So that's typically a risk area for people who are travelling a lot and who are Australians as to whether they can show that what they have overseas is permanent in the context of permanent place of abode. One of the common questions is for Australians who start to live and work overseas, but they still want to keep their property in Australia. And the question is, well, does that continue to make a person a tax resident of Australia? And the answer to that really depends on what you do with the property. So, for example, if you have one person in the family who goes and lives and works overseas, but the rest of the family stays in Australia and continues to live in that family home, then that's probably still going to be a usual or settled resident, even for the person who's living and working overseas. By contrast, people who have properties in Australia who then move overseas with their family and who might either sell the family home in Australia or rent it out on an arm's length basis to tenants, that's then unlikely to be a home that's available to them in Australia. So you potentially get a different result in those circumstances. If you're living and working overseas, then depending on the country, you might also be paying tax in that overseas country. And the question that needs to be determined then is whether you're paying tax in the overseas country as a tax resident of that country, or whether you're simply paying tax in that country because you're performing the work in that country. Now, the reason that the distinction is important is that some countries Australia has a double tax agreement with. And typically what happens with the double tax agreement is that it allocates taxing rights to one country over another. So for individuals, there are a series of what are called tiebreaker tests, and you work through these tiebreaker tests to then determine which country has taxing rights over different sources of income. There's also in these double tax agreements often employment articles, and what that does is it also assigns taxing rights to a particular country, usually the country where the services are being performed. Even if you're not a tax resident of that country overseas, what would then happen is that you would then need to include in your Australian income tax returns all of the income, because as an Australian tax resident you have to declare all of your worldwide income, but you should be entitled to a credit for any of the tax that you've paid in the overseas country.
For further information, please contact Fletch.